Draw near, give attention, and ye shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. Good afternoon. We have two cases on our docket this afternoon. We will take them in the order that they are listed and take a brief recess in between them to reconstitute the panel. The first case, number 23-1932, Abraham Omar McCray versus State of Florida. Appellant's counsel.
Thank you, Chief Judge Osterhaus. May it please the court, Mose Bracey, on behalf of Mr. McCray, I'd ask to reserve 4 minutes for rebuttal.
Noted. Thank you.
This case is about a trial judge not allowing a criminal defendant to present evidence in support of his theory of defense.
Let me ask you a question about
Yes,
that.
sir.
I'm sorry to cut to the chase for you, but and I appreciate the thorough brief you wrote. But why didn't defense counsel try to present any kind of medical expert testimony about whether those bruises could have been inflicted earlier?
Yes, sir. Well, Judge Thomas, I can't speculate as to why they didn't.
But isn't that a problem for your argument?
I really don't think so, sir. Okay. I really don't. And I say that because I think the question here really is where, at least where the bruises, where this, if we could call it, the evidence of the prior violent struggle, where that's concerned, I would say that, the issue is whether it's relevant, which I think in this case comes down to, does it tend to establish a reasonable doubt as to his guilt? And I think that even without medical testimony, a jury could have reasonably inferred that since that incident happened a few days prior, that those bruises could have, that struggle could have caused the respective injuries. So I think it would have been great if there would have been testimony. Of course, I'm not exactly sure if it would have been allowed, but I don't think that would be necessary.
And who was going to testify as to the prior incident?
ARB herself, the victim. Yes, sir. And so if I could, it may help a little bit on this point to focus specifically on her testimony, the testimony that described the nature of the struggle, as well as the testimony that described the nature of the injuries. And so here I'm looking at 133 through 37 of the trial. And here, in terms of the nature of the prior struggle, ARB testified that a few days prior to the incident at issue, there was a violent struggle in a bathroom. ARB was basically lured into a bathroom, and then somebody tried to take advantage of her, and she basically got into a violent fight with them. During the fight, she was pushed into a wall, she hit the wall, and then she got into this violent struggle from the wall to the sink where she was forcibly pushed against the sink and fought a grown man. And she went on to clarify that she was pushed forward over the sink by the man. So that's the basic evidence we have of the struggle itself. In terms of the injuries, and here I'm looking at pages 68, 90, and 105 of the trial.
And I'm sure we'll hear from the state regarding their view, but why did the state argue to exclude this evidence? They argued it was not relevant, but I'm just curious, typically in a criminal trial, this would likely come in.
And I'm sorry, Judge Thomas, you said, why did the state argue to exclude
Yes.
it? Well, my understanding, the way this initially came up was prior to trial, the state filed a motion in limine, and they had the hearing prior to trial. The defense basically at that point just represented what they believed the testimony would be. The state didn't want to have a proffer at that point from ARB. The state didn't object to the representation. The defense then ended by arguing this is relevant to our defense. The state basically argued it wasn't relevant. And then during the actual trial, the defense during cross-examination of ARB again tried to get in, tried to introduce that information. There was an objection, and at sidebar, as I recall, it wasn't allowed.
But the state's whole argument seemed to me to be based on the idea, unless I'm misreading this, that because there was no medical testimony regarding the nature of those bruises, it was not relevant. I mean, had there been some testimony that if your client had presented or proffered some testimony that, look, we have a medical expert, he's going to testify that the bruises that were observed on her during the sexual assault kit examination could have been inflicted 2 days earlier.
Yes,
because that was lacking, as I recall, the state argued it's not relevant. There's no evidence to show that, and of course, she testified that, well, the prior incident only involved the upper half of my body. But I'm trying to get a handle here on
Yes, sir.
exactly why this would be excluded.
Yes, sir. Well, Judge, of course, I'm arguing it should not have been
I know
excluded.
you're arguing to the
Yes, sir.
contrary.
What I would say is that the state's argument, which I believe you're more or less accurately describing, and I believe that also more or less describes the court's reasoning as best I could tell. I mean, basically, the court seemed to agree with the state. I think fundamentally what that argument and reasoning gets wrong is the bar is exceedingly low for testimony to be relevant. I mean, the case law says things like contrary testimony goes to weight, not the admissibility, that it's not the key.
Well, I know you have two primary arguments here, the other regarding the knowledge that she found out about the rumor about the recordings. But on this one part of the case, tell us why it's not harmless.
It's not harmless, yes, sir. Just focusing on issue one exclusively?
Yes.
Yes, okay. Because I will say, Judge, I mean, I do think they can be considered cumulatively.
Of course.
But with respect to this argument, and I will say the argument I'm about to make also would apply individually to count two as well as cumulatively, I think the basic 2 points I'd want to make is that the permissible evidence, meaning the evidence that was allowed in, was not clearly conclusive. At the same time, the excluded evidence, the prior violent struggle, ARB learning of the rumor, it would have had an impact. And I say that.
I mean, it's interesting because in the federal courts, the standard is actually different.
I'm sorry, in
the federal courts,
Yes,
the
sir.
standard is actually, shall we say, more lenient towards the prosecution.
Yes, sir.
So, but in state court under DeGuilio, it's a tougher standard for the state to meet.
Yes, sir.
But you had her testimony, you had, what else against you?
Well, really, the two main things, Judge, were the presence of the injuries and ARB's testimony that basically she was drugged, passed out, and couldn't remember, much less have, consented to the sexual encounter.
And it seems like the injuries were a pretty big deal, and that this would have been a he said, she said oriented case, but you have all this bruising, that all the evidence was that this bruising came from, as a result of the crime here.
Yes, sir.
And the potential bruising from being, I think it said violently attacked and thrown around the room from a few days earlier was potentially kept out. I guess the part of that doesn't connect for me is that there was bruising to the cervix. Now, I get the physical bruises to torso, arms, maybe thighs, inner thighs, I'm not sure I get, but why would your argument apply with respect to inner thighs and cervix?
Yes, sir. Well, just a few different points, if I could, related to the bruise on the cervix. One, I don't think, even if the bruise to the cervix could not have realistically come from the prior violent struggle, I don't think that alone would render evidence of the prior violent struggle irrelevant because, of course, there are other injuries that ARB says testifies happened during the encounter. I really think, and of course, the bruise to the cervix would really have nothing to do with the evidence about ARB learning of the rumor, I don't believe. I think where the bruise to the cervix would really come in would be in the harmless error analysis. My position would be that even if the bruise to the cervix could not have reasonably been caused by the prior violent struggle, the errors still would have been harmless. I'm sorry, the state would still not be able to prove that the errors were harmless. And I say that, again, thinking about kind of the permissible evidence and the impermissible evidence or the excluded evidence. In terms of the permissible evidence, that bruise to the cervix, the evidence certainly did not exclude the reasonable possibility that that bruise was from something other than non-consensual sex between Mr. McRae and ARB. And I say that particularly because of what the sexual assault nurse testified to. One, she said, I can't tell you exactly what caused this. She said it could have been intercourse. She certainly didn't say it had to have been intercourse, much less it had to have been non-consensual intercourse. She also said that even though it could have been caused by friction or touching, it also could have been caused by, she used some somewhat technical terms, but I think she said a coagulation disorder, hemorrhaging, or bleeding. So she said.
But now he told the law enforcement that they had consensual sex.
He absolutely did, Judge Thomas. And I want to be clear, the verdict here certainly did not turn on whether they had sex.
I
It turned
understand
on.
that, but I mean, so he said we had consensual sex. He provided some rather lurid details.
Yes, sir.
And then she testifies, no, there was no consensual sex. I woke up, I had these bruises, and people told me something happened. And how is that likely not harmless?
Okay, well, because in essence, the permissible evidence, it came down to her credibility and the presence of the injuries. I mean, there were no independent witnesses. There were obviously no recordings. Mr. McCrae, by way of his statements to Detective Allen, said, it was consensual, which again, that's what the whole verdict turned on. So I would argue that even amongst the permissible evidence, there's some reason to question ARB's testimony.
Well, so let's play that out then.
Yes, sir.
Let's say that the jury hears the excluded testimony.
Yes, sir.
Maybe all of it. Let's just say, obviously, that's what you have to do with a harmless error analysis. So the jury hears she had an incident where she was assaulted, physically assaulted, a couple days prior, and that afterwards she heard about this rumor that purportedly she had engaged in group sexual activities and it was recorded. That's it. So that's it, right?
Yes, sir, essentially.
Right.
Yes, sir.
So the jury hears that. She testifies. She was going to testify regarding the prior incident. That didn't cause these bruises. In fact, didn't she testify, if I'm not mistaken, that I didn't have any bruises before I woke up?
She did.
So
Yes,
the
sir.
jury heard that.
Right.
So you your defense counsel cross-examines her and says, well, wait a minute, you had this prior incident and you were physically assaulted. Didn't that cause any bruising? Well, she's going to testify, as she did, no.
But she's also going to describe the prior violent struggle. So,
Correct.
so the jury, so I think largely what I hear you getting at, Judge Thomas, is it came down to her credibility. And
I know, but logically, I'm trying to decide how the jury hearing about the prior incident and her testifying, as we know she would have for a fact, that no, that didn't cause any bruising. The bruises appeared after I woke up, or the handprint, et cetera. So the jury's going to decide, oh, we think you're lying and that you were bruised from the prior incident, and that I guess your whole theory would have been then, look, she found out about the rumor. She denies having bruises from the prior incident, but you, the jury, can decide whether that's credible. She testifies that she never consented to the sexual activity. He doesn't testify, as I recall.
no, sir, but his statements that it
I
was
understand
consensual.
that.
Yes, sir.
So his inculpatory, or what I guess you would call them exculpatory statements come in.
Right.
That, oh, we had sex and it was consensual. You think the jury would have returned a not guilty verdict on that?
Well, I think there's a very good chance, but I would also point out, Judge, and I know this is kind of splitting hairs, of course, the question is not whether they were
I
returned,
understand.
but whether, what I would say is this. I think that if the excluded evidence would have come in, it would have, the jury would have had to consider it. It would have weighed on them. It would have at least given them some pause. Maybe it would have just had a holdout. Maybe it would, because the point is here.
Well, DeGuilio says would it have affected the verdict, which I'm not sure is, well, it's not the standards used in federal court.
Yes, sir.
So, but it's interesting, this is an interesting harmless error case, because what does that mean, affect the verdict? In other words, you might have had a lesser of battery? Was there a lesser included? I doubt it.
I
don't recall.
I
I
can't
don't
say for
recall.
sure, Judge, I'm sorry, but I
But,
think there may have been, I'm not sure.
Right, let's just assume there was a
Yes,
lesser
sir.
included of battery.
Yes, sir.
And so, i.e. affected the verdict means they might have come in with a lesser?
I think so.
Or they might have not been able to reach a verdict. That's
I
what
think
you're saying?
that's right. Yes, sir. I mean, it's a very, very high standard. The state has to prove beyond a reasonable doubt, and the Florida Supreme Court case law is clear. I think this is Knowles versus State. It doesn't have to substantially affect the verdict. It just has to affect the verdict. And so, of course, it's hard for me to basically prove a negative, I feel like is what I'd like to be able
So
to
in
do.
the federal court, you just look at whether or not there was overwhelming evidence of guilt, i.e. prejudice. In fact, I think, if I'm not mistaken, it's the same standard as prejudice from ineffective assistance counsel type analyses, right?
Yes, sir.
I.e., is there overwhelming evidence, so there's no prejudice? But that's not the standard in state court.
Yes,
I
sir.
acknowledge
And
that.
I wouldn't want to misspeak, Judge, but what I would say is if the court was considering,
I'm just curious, isn't that a more logical standard? I understand it's not, and I understand DeGuilio's been around for a few decades. But isn't that a more logical standard? Because aren't we being required to engage in some fairly serious speculation here?
Judge, I don't think so. I mean, I think either way, there's going to be an element of, I don't want to say speculation, but an element of kind of gaming out how it could have gone, or even maybe how it went in the jury room. But I think that, certainly the Florida state courts have the prerogative, as I understand it, to enact the DeGuilio standard. And I would the one thing I would ask is if this court was considering just kind of addressing those concerns, that it would at least allow some supplemental briefing on that.
It's binding precedent.
Okay, yes, well, I just.
So you don't have to worry about that.
Well, I know it's binding, but if there was some discussion of that, Judge, I would be interested in contributing something that was a little more informed than what I have to offer today.
Well, harmless error is always on the table.
Yes, sir. No, I mean in terms of addressing concerns with the DeGuilio standard.
I don't think anybody's arguing for a certified question whether DeGuilio should be reconsidered, so.
Yes, sir.
You don't need to focus on that.
Yes, sir. Well, one thing I do want to say quickly on the harmless error, because I can tell that, there's some thoughts here about that. The excluded evidence would have had an impact, and I know we've touched on this a little bit, but evidence of the prior violent struggle, one, would have offered up a reasonable alternative in terms of what caused the injuries. Also, I want to be clear that it would have offered up a reason to question ARB's credibility, which again was critical because she not only said that bruises weren't there, or the bruises happened during this encounter with Mr. McCrae. She said, quote, there couldn't have been another incident where she received the bruising, end quote. And of course, if this prior violent struggle happened just a few days prior, that would have impeached her testimony on that point. And then on ARB learning of the rumor, again, that would have directly undermined her credibility because it would have offered reason to believe that out of embarrassment, shame that perhaps people knew that she had even consensual sex with Mr. McCrae and almost a threesome with his brother, that could have given her a motive to falsely claim, I passed out, I was drugged, I don't remember. And so again, that would have undermined the most crucial piece of the state's evidence, which was basically ARB's testimony. So unless there are further questions, I'd reserve the balance of my time for rebuttal.
Thank you, Mr. Breeze.
May it please the court, Julian Markham. If I could, just starting with issue one, I would like to address the timing in her testimony with respect to the amount of time that lapsed between the initial incident and the incident at issue here today. She was asked during her proffer by defense counsel if the earlier attempt to commit sexual assault had occurred within 2 days of the sexual battery, and she said no, it was not 2 days, it was within a week, but not 2 days. The phrase within a week usually connotes a period of time longer than a few days. Obviously, it wasn't in excess of a week, but
So is your point there that if it was 3 days prior, that the bruises would have been gone? And
not that
if the first attack would have happened and it would have resulted in bruising, then the bruises would have been gone?
it's the further out that the initial incident occurred from the instant one, the more likely that it would have been.
But that all goes to the weight, right?
Well, it also.
Not admissibility. I mean, the testimony wasn't, the ruling wasn't based on the idea that it was so attenuated. The ruling was it was not relevant.
Right.
So, whether the jury, the fact finder would make those kind of determinations. In other words, your argument, the state's argument, the prosecution's argument would be, look, it was a week ago, there's no way. But the jury would have been able to hear that and decide, okay, well, these bruises were not inflicted by that prior incident. So let me ask it, maybe ask it a different way.
Okay.
Do you think that the prior incident was irrelevant?
I think based on the information elicited during the proffer, the relevancy wasn't established.
I'm sorry?
I think based on what was established during the proffer, the relevancy of the earlier incident wasn't established.
Why not?
Why not?
Why not?
Because I don't think that defense counsel was successful in establishing a connection between any of the injuries she described finding on her body on awaking in the tent of the appellant's brother after her period of unconsciousness were linked by that testimony to.
But I mean, the evidence, and again, I'm just asking
Sure,
in terms of
I understand.
clarifying the issue, but as I recall, the nurse testified that I could not tell you when those bruises were inflicted. Or there was some testimony to that effect, as I recall.
She testified that she could not tell after the fact when they were inflicted. The victim testified during her proffer testimony that she never had the bruises.
Now, I understand that, we know that, but the nurse testified that I can't tell you when those bruises occurred.
Right. But the only evidence we have of the bruising to this victim was her testimony.
Well, that kind of makes it more credible, right? I mean, her own testimony was that she'd been the victim of a prior physical assault.
Right, but that she hadn't sustained any of the injuries she described, in particular to her lower body.
Let's talk about harmless error. Just, at least for my purposes, assume
Okay.
that, just for the sake of argument, that we decide that the exclusion was incorrect.
Okay.
Why would you suggest it's harmless?
Well, because even if evidence of the prior incident came in, it doesn't explain, as proffered, as her testimony was proffered, the injuries to her inner thighs, and in particular, the bruising to her cervix, which was so unusual that out of over 70 examinations by this particular SANE nurse, she only photographed this one and 2 others.
But the
And-
nurse also said that that could happen in the course of consensual sex, correct?
Did she say that? I don't remember her saying, I suppose it's possible, but she said it was very unusual for those, for that bruising to appear.
That's what I recall, but go ahead, go on.
Okay. So you have that bruising, and the argument by the state, and I think it's common sense, is that injuries of that nature occur when the victim is not prepared for a sexual act. And you also have the appellant who admits to having sexual relations with the victim. And I just don't see how this evidence of this earlier incident, at which everyone agrees was not consummated, would have produced these injuries. There's no
But I mean,
testimony.
doesn't that sound like a closing argument? I mean, so it doesn't, I mean, it seems to me that, in a sense, we're hearing you make a closing argument to the jury that, look, had this evidence been admitted, ladies and gentlemen of the jury, you must use your common sense. There's this injury to the cervix that could not have been inflicted in the prior incident. whether or not you think she might have had some bruising from the prior incident, it doesn't destroy her credibility regarding the other bruising that occurred here, which she denies. And then on top of that, ladies and gentlemen of the jury, the fact that she heard about this rumor and there had been recorded group sex, she denies that she had consensual sex. He claims that she did. You use your judgment, and I mean, isn't that what the harmless error standard is kind of about? Which is, if it could have affected the verdict, then it can't be ruled harmless.
Well, I'm just not sure how what was proffered could have affected the verdict, because there was just nothing proffered to.
Well, there was proffered that she was thrown against a wall, thrown against a sink.
Right.
I mean, a pretty violent encounter within the.
It was a violent encounter, but what she described in the encounter, I can read to you what she described. She
Do you
was
think that prior encounter couldn't have resulted in bruises on her torso and on her arms?
She testified, well, the injuries she described finding on herself were bruises to her inner thighs. I think it's just not established how being pushed into a sink could have caused an injury to the inner thighs. It just doesn't make sense. There was no testimony with regard to her initial, the assailant at the initial incident, grabbing her inner thighs. In fact, I think she specifically.
But I mean, there were injuries to her upper torso, right?
Right, but the only injuries that that came into before the jury were a cut to the chest and a grab mark on the arm.
Well, that certainly could have been caused by the prior incident.
Yes, it could have, but they never elicited during the proffer that she was grabbed on the arm or that she.
I thought that's what she said. She was grabbed and thrown into the wall.
But
and
not
then
on
she
the
was
arm.
thrown into the sink.
But not specifically on the arm. There's just no connection that's been established. And as the proponent of the evidence, the appellant should have elicited that during the proffer.
What about the recording? What's your harmless error argument there? Assuming it's error, I'm not asking you to concede that.
Okay, thank you. The defense theory was that the rumor motivated the victim to fabricate this whole incident, or her account of this whole incident. However, she testified that on waking inside of the tent, she found the bruising on her and immediately walked out and started investigating what happened to her because she did not know. She wanted to clear this up. And she started talking at that time to members in her dorm, other residents in her dorm, about what happened. And this process was ongoing during the time that she heard this. She started receiving text messages or phone calls that conveyed this rumor of her having sex with multiple other people.
Of course, it was just a rumor, right?
It was just a rumor. It was just a rumor. So the rumor was not relevant because the victim was already suspicious in investigating the incident before she even heard it. And it wasn't until her discussion with the counselors at the facility that she actually received this rumor from Fat Frank, and they actually started looking it up on their computers to see if they could find it on YouTube or on Facebook. Moreover, she never called the police, nor was any evidence presented to establish that she initiated contact with the shelter's staff. All of this was done on her behalf. And she's never changed her, she's never pointed the finger, in counsel's words, at the appellant. She's never said that she was sexually battered. She said she doesn't know what happened. There's just no evidence, in other words, that this rumor had any effect on her at all. So if there are no further questions, I'd ask that the state, that
Thank you, Mr. Merkel.
My hope is to touch on a few things related to harmless error, and if I have time, something briefly on the rumor. But in terms of the harmless error, I just want to start with a few things. You know, one, in terms of whether the injuries could have been caused by the prior violent struggle, I want to be clear that, you know, ARB said he was trying to take advantage of her and he bent her over the bathroom sink. And I think it's certainly reasonable to infer that when that's happening, somebody can grab inner thighs and push them on, you know, push the person over by their back. So I think all of these injuries, other than the bruise to the cervix.
What about the timing on the rumor?
Okay, yes, sir. Well, Judge, here's what I would say there. I think that the timing was actually clear, that she learned of the rumor before she started telling people, you know, I was drugged, I passed out, and I received the injuries in this encounter. And I say
State
that,
asserts to the contrary.
sir.
Your learned opponent asserts to the contrary.
And
Yes,
the
sir.
record seems to indicate that she said that immediately to him in the tent, which elicited him to have a sympathetic response and to gather her glasses for her and what have you. And she attributed that right in the tent in her testimony to the fact that she had told him that she couldn't remember anything.
Well, of course, a couple of things there. I mean, that is according to ARB's testimony, that she told Mr. McRae that. You know, and again, it's her credibility that's the concern. I mean, under the defense theory, she was not, you know, she was not telling the truth when she testified. And
I understand that, but what does the testimony show regarding when she heard about this
Yes, sir.
rumor?
Yes, sir. Well, on pages 100 through 101 of the trial transcript, she says she woke up and was trying to piece things together. She didn't know what happened to her. She talked to people to try to figure out what happened to her. And at that point, she started being called by people who said things she found extremely offensive. At that point, the state's hearsay and I believe also content objection was sustained. And so I think that when you look at that, and I would also note that on page 97 of the trial transcript, the defense represented without state objection that at the time of hearing of the rumor, she says she doesn't know anything that happened. Then she says, I'm a victim. She's telling the officers something must have happened to her. And so I think that, you know, if she's trying to figure out what happened to her, she's not at that point in time saying, I was drugged, passed out, and received these injuries. But here's the thing. Even if there's some lack of clarity of exactly what the timing was, that goes to the weight, not admissibility. Furthermore, I don't even know even if we knew that the timing was rumor first, I passed out and was drugged later, I still think it would be relevant because the question is, was she credible the day she testified? And, you know, she still could have changed her testimony over time. Now, the state may have been able to introduce a prior consistent statement, but that's a whole other issue. So if I could just very quickly touch on.
Briefly sum up.
Yes, sir. Yes, sir. Well, one, I would just say the harmless error is a very, very high standard. It's a very high standard. And to close, you know, in Vanier versus State, V-A-N-N-I-E-R, the 4th District basically stated, where evidence arguably tends to show a fact that may lead a jury to exonerate a defendant, the trial judge's discretion is reduced. And here, the excluded evidence, you know, it tended to show certain facts that might have led a jury to finding him not guilty. So the trial judge abuses discretion. We'd ask this court to reverse and remand for a new trial. Thank you.
Thank you, counsel. We'll take a brief recess.
All rise. All rise.
Thank you. You may be seated. We have the second case on the docket. Is the appellants ready to proceed? Yes, sir. Are the appellants, excuse me.
Your Honor, thank you. I'd like to reserve 7 minutes for rebuttal, if I may.
And I understand this is a very important case, and so I plan to be fairly liberal with the time. You may receive questioning on a variety of matters, so we won't be a strict timekeeper today.
Thank you, Your Honor. May it please the Court, Andy Bartos and Dan Norby, on behalf of the legislators and the legislative staff members. 11 years ago, in Apportionment 4, the Florida Supreme Court recognized a legislative privilege founded in the Florida Constitution's strict separation of powers clause. It recognized that protecting legislators and legislative staff from entanglement in civil litigation on account of their speech and conduct in the legislative arena is critical to a proper separation of powers and ensures that the legislature can accomplish its role of enacting legislation in the public interest without undue interference. But it defeated that very purpose when, instead of establishing clear, bright-line rules and an absolute privilege in civil cases, it established an open-ended, amorphous balancing test that encourages individual trial judges to resize and reshape the legislative privilege from case to case and even from day to day.
Thank you, counsel. Before we get to the merits of it, let me ask an initial question on jurisdiction. You represent non-parties to the appeal, correct? I mean, to the trial.
Yes, Your Honor.
So how does this court have jurisdiction?
Your Honor, under the Expedia decision, the court recognized that an appeal from an order denying, in part at least, a motion for a protective order is appropriate when non-parties appealed in that case. We think that that case is...
Did we address jurisdiction in Expedia?
I'm sorry?
Did we address jurisdiction?
Yes, the method by which the case reached this court, yes, it was considered a final order and an appeal
But
from...
it's not a final order, right?
It is a final order with respect to the non-parties, and that's what the court found in Expedia.
I mean,
that-
this is a case that's closed. Supreme Court just heard oral argument last week.
Yes, Your Honor.
The trial, the final judgment is entered. We reversed. That's being appealed now. And so I just need more information on how we have jurisdiction over non-parties. And didn't it require a petition for writ of certiorari?
So, Your Honor, we believe that the proper method was to take an appeal, a notice of appeal, because of the Expedia decision.
But I don't recall Expedia dealing with whether jurisdiction was established. I mean, whether the parties had to file a writ of certiorari.
Expedia found that an appeal is the appropriate path, and the distinction between that case and Apportionment 4 was whether it's a non-party or a party. So a discovery order is typically non-final when it's directed to a party, because the party, of course, can take the appeal at the end of the case. And a discovery order like this, directed to non-parties, is final as to those non-parties, and therefore an appeal is proper, and that's what Expedia found. And we believe Expedia is panel precedent on that issue, and we think it's on all fours with this case.
If I could kind of shoot ahead a bit and address on the mootness issue, the legal consequences exception. I looked back to see if we had any attorney fee or cost issues here that would bleed into the legal consequences analysis. And I see in the original complaint there is a request for costs under 86081. I don't see in the stipulation of the parties that there was any, concession, withdrawal, et cetera, regarding any outstanding cost amount. So I guess my question to you is, this court and recently other district courts of appeal have ruled that if there's an outstanding fee and or cost issue, that can sidetrack or moot, I guess, a mootness argument, and really there to be a focus aside from the mootness on the case going forward to address those issues. So can you talk about that for me, and do you think the outstanding, at least cost request, is relevant to legal consequences?
Your Honor, I don't believe there's any cost issue related to the non-parties. So I don't think there's a cost claim that would be relevant to this case. We would rely on primarily on the mootness issue, rely primarily on this case being one of great public importance and one that is likely to recur, which are also exceptions to the mootness doctrine in an appellate court.
How is it likely to recur again?
Certainly not, Your Honor, within this case, but we don't think that's required in order for the likely to recur exception to apply. And we have seen time and...
If this court's opinion in Black Voters Matters is affirmed, there won't be a redistricting again for 6 years?
Redistricting, no, but the reason that apportionment 4 is so critical to the way that the legislative branch functions is it's not simply a redistricting case. It establishes a general rule and it establishes a balancing test that affects the way that the legislature does business. And when the legislature cannot count on the fact that it will not be hailed into the court because of the part.
Well, since you're talking the merits of the case, let's talk about that a little bit. I assume you watched the oral argument last week?
Yes, Your Honor.
So did I, most of it. And our opinion was not discussed at any length of time in that case, right?
I believe.
Well, the legislature did not argue the position that this court relied on in its en banc majority opinion.
The Secretary of State's brief addressed the Jingles factors, and the legislature's brief addressed
And the Secretary of
equal
State
protection.
briefly addressed our argument, and as I recall from watching his argument, he briefly said that what we essentially held, and that was about the only reference to our opinion in the entire argument. Is that correct?
I don't recall, Your Honor. I think the court's questions were primarily directed to the equal protection
Right.
analysis.
I didn't hear any justice, except perhaps at the very end, regarding a question about our view of their precedent, discuss our opinion in any way or
Right.
fashion or
There-
at all.
There was certainly discussion.
And that was the basis of the jurisdiction, right? Was our opinion.
Yes, Your Honor.
And it wasn't discussed. The reason I'm verifying that is you're here asking us to, I assume, write an opinion that says, by the way, Florida Supreme Court, we think you were wrong in apportionment 4. Right?
Yes, Your Honor.
How much weight do you think that would be accorded in the Supreme Court?
I think, Your Honor, that the court would be very open to reconsidering apportionment 4. I think that this.
Because in Black Voters Matter, we had an en banc oral argument.
Yes, Your Honor.
We wrote an en banc majority opinion. There were dissenting opinions. There were several concurring opinions. And the opinion wasn't even discussed in the argument. I'm not being critical. I'm just stating a fact.
I understand.
And so why would that court be concerned in this very same case with what we might think about apportionment 4?
Yes, Your Honor. I think one answer is to look at Justice Kennedy's dissent from apportionment 4 itself, where he was very critical of the majority's resolution of that case.
I understand. He's a justice on the Supreme Court. I'm sure they'd be quite interested in hearing his views possibly down the road. But my question is, you're here asking, and I'm not being critical, but I'm curious as to why you would think in this very same case that was just argued at length, not a week ago hardly, where our opinion was not discussed at all by the lawyers, essentially. The Secretary of State briefly addressed our opinion with one sentence, by the lawyers or by the justices. And in fact, the lawyer for Black Voters Matters said our opinion was irrelevant. In fact, they said it was brazen and wrong-headed, was the language they used. And none of that was discussed.
I think the reason that this opinion would attract the court's attention and interest is that redistricting law, the merits of redistricting law, as Your Honor knows, is obviously very, very complex and very nuanced with the Voting Rights Act, the Equal Protection Analysis, the Fair Districts Amendments
I wrote
provisions.
an opinion on it.
And there, as this court knows, there are many different ways to look at it. This court, there were concurring opinions and so forth.
I co-authored an opinion.
Yes, Your Honor. And whereas I think in this case, it's a much more straightforward, direct question of whether the separation of powers clause in the Florida Constitution protects legislators from being hailed into court because of what they say and what they do in the legislative process. That doesn't involve federal principles or equal protection or Voting Rights Act
Do you think they'd be
principles.
more willing to listen to our view that they were wrong because it's a simpler issue?
I think because redistricting is a uniquely involved and complex issue that everybody, I think, and speaking certainly on this side of the courtroom, everybody takes a different view of redistricting law because it is so complex and so involved. I think the separation of powers argument is very clear and very simple. It's a straightforward state law issue.
So I want to just confirm, you do want us to write an opinion?
Yes, Your Honor. We recognize that the court is bound by apportionment 4. We recognize that the opinion would likely acknowledge that, but at the same time.
Well, it would have to, right?
Yes, Your Honor. If there is an opinion, it would have to acknowledge that. But at the same time, we think that this is ripe for resolution for the Florida Supreme Court to revisit apportionment 4, and that as the certification of a question of great public importance would be the appropriate vehicle to bring that to the Florida Supreme Court's
Well,
attention.
what I'm struggling with is, whether I agree or disagree with apportionment 4, I'm to practice judicial restraint with respect to keeping within my bounds here, and I guess address Appley's argument that you basically are only here trying to get us to pass this through, and that this is technically moot. So best arguments on why this is not a moot case and why we should address Florida Supreme Court precedent, write an opinion, and send it up.
Yes, Your Honor. I would say, number one, just strictly as a legal matter, we think that this is a classic example of the application of the mootness exceptions that we mentioned in our brief. It is an issue of great public importance, and it's likely to recur. And those have been well-recognized exceptions that permit appellate courts to decide cases that have become moot. It's an issue of great public importance, and this is really, practically speaking, why we would urge the court to write an opinion on this. It is an issue of great public importance because it affects the legislative branch in its day-to-day operations. It is not, the injury doesn't arise simply once the discovery request is served. It arises as long as legislators who are acting in the legislative arena and who are considering what part to take in the legislative process know that what they decide to do, how they vote, what speeches they give, what positions they take, what committees they serve on, can subject them to civil litigation. And that has the risk of impacting the legislative process in ways that it should be insulated from. As long as legislators have to ask themselves, what will happen to me if I vote this way on this bill? Will I be hailed into court if I agree to serve as the chair or vice chair of that committee? Will I receive a subpoena if I take a position on this, or if I speak out, or if I give a speech on the floor? Those are questions that legislators should not be asking themselves, because once they begin to ask themselves those questions, this precedent impacts the legislative process. It impacts the output of that process potentially, and that's very serious. That's why we have a separation of powers provision in the first place. So
Counsel, let me. This is all well and good, but let me try to redirect you back to the core question of mootness, which concerns me a lot.
Yes, Your Honor.
They withdrew their requests with prejudice. They withdrew their motion to certify to the Florida Supreme Court. Are you familiar with the financial impact estimating conference decision that we released a few weeks ago?
Not in detail, but yes.
Yeah, mootness, because it went away. So
Yes, Your Honor.
I have trouble understanding how, in other words, the merits speak for themselves.
Yes,
Big,
Your Honor.
important issues, got it. But not this case, maybe. How do you overcome the mootness problem?
And while that sounded like a merits argument, I was actually addressing mootness because of the great public importance exception to the mootness doctrine. This is why it's of great public importance. And that's why an appellate court has the authority to decide this case, even though it's moot, because it is of great public importance, because it impacts how the legislature does business, and secondarily, because it's likely to recur, which is a separate exception to the mootness doctrine. So,
But as I recall, you argued in your brief that the likely to recur is not really a binding criterion on this court.
what we argued is that for an appellate court, the
Right.
mootness exception, one of the mootness exceptions is likely to recur. We don't believe that an appellate court can only hear the case if it evades review. That's the component that we believe applies only at the trial level. If it's likely to recur, we think that an appellate court can decide it.
I mean, how do you think this is likely to recur?
It's likely to recur. We've seen time and time again, both in state and federal court, parties attempting to depose legislators, issuing deposition subpoenas, document subpoenas.
Wouldn't it be better just to wait, especially given the posture of black voters matter, this case, to a situation where a subpoena is served?
Yes, Your Honor. So not likely to recur in this case. But we
Well, I
don't-
know that.
Yeah.
But
we
I mean,
think
in the future.
in the future, yes, Your Honor, we think that certainly as long as apportionment 4 is on the books, it invites that sort of discovery. It begs for it. Parties will continue to argue that the balancing test favors them, and that balancing test encourages that, and it encourages trial judges to allow some form of discovery. I see that I'm beginning to get into
I'm
my
going to
rebuttal.
give you an additional 5 minutes, but you don't have to use it, but if you'd like to use it, and
Thank you,
for
Your Honor.
both sides.
Thank you, Your Honor. So that's our.
Well, back to the merits then. Assume we agree with you that it's not moot, and we agree with you that the Supreme Court would like to hear our opinion that, by the way, you got apportionment 4 wrong. Despite what occurred last week and despite the fact that this case is closed, there's a final judgment in it. For the sake of argument, if discriminatory intent, if I recall that factor, which was not a factor in Black Voters Matter, was not argued. But if that is argued in a similar case or some type of similar litigation, is the thought process of a legislator relevant?
I think intent.
Because you would agree in another redistricting case, right? Discriminatory intent or animus or that kind of thing could be argued in the future. It wasn't here. Now, I did hear in the oral argument, as I recall, counsel for Black Voters Matter telling the Supreme Court that, well, if you want to go down the road of looking at history of discrimination, we would ask you to remand. I guess that wouldn't necessarily involve animus of current legislators, but assuming that could possibly be at issue in a future redistricting case or a similar type of case, would the thought processes of the legislators under the Fair Districts Amendment, for example,
Yes, Your Honor.
be relevant?
Yes, Your Honor. So the intent of the body can be relevant depending on the claim, but that doesn't destroy the legislative privilege. And
How do you get to animus then? How do you discover alleged animus?
You can discover animus or intent in different ways. The federal courts have established under the Village of Arlington Heights framework a method of assessing discriminatory intent under the Equal Protection Clause that does not involve deposing members of Congress or members of a state legislature. It looks at various factors that the plaintiffs must prove. The plaintiffs would have at their disposal the entire legislative record. They would have the ability to serve public records requests. They would have the ability to present expert testimony and cite circumstantial evidence as well. What they cannot do is intrude on the legislative process. The Florida Supreme Court had no difficulty in the first apportionment case back in 2012 finding intent without legislator depositions. In the Tenney versus Brandhove case, Justice Frankfurter, writing for the court, wrote that an unworthy purpose does not destroy the privilege. In that case, it was an immunity case, but those are twin doctrines. And there are federal cases all along the way that reject the argument that simply because motive or intent is at issue, legislators no longer have protection from
What do you say to
discovery.
the appellee's argument that there is no speech and debate clause in Florida?
Yes, Your Honor. So,
And that the Fair District Amendment specifically makes under Tier 1 intent an issue?
Yes, Your Honor. So speech or debate clause, there is a separation of powers clause in the Florida Constitution, and it is an explicit provision that Florida courts have always strictly enforced, and that is the basis for the legislative privilege. So the fact that there's no speech or debate clause doesn't end the inquiry. In fact, on that issue, we agree with Apportionment 4, where it found that there is a constitutional legislative privilege in the separation of powers clause. I would also note there is no express constitutional protection for state legislators in the federal Constitution, and nevertheless federal courts protect state legislators even more so, ironically, than the Florida decision in Apportionment 4. So federal courts under the federal common law provide broad protection, and increasingly so. And as we've seen in federal decisions from In re Hubbard in 2015 going to In re North Dakota most recently, one after another, seem to be coalescing around this idea that in civil litigation, the legislative privilege is absolute. They've not yet found the case that is the exception to that rule. So notwithstanding the absence of an express speech or debate clause, we think there's ample reason within Florida's strict separation of powers clause to find that the legislative privilege is absolute, and it would be paradoxical, we think, for the Florida to have one of the strictest separation of powers clauses in the country, and yet one of the weakest legislative privileges. And
Well,
really,
what about the argument by your opponents that the Fair District Amendment is explicit and makes legislative intent, i.e. their argument, legislators' intent, relevant?
and the fact that it's relevant doesn't turn back the legislative privilege. There are other claims as well, equal protection claims and other claims that involve intent or purpose or motive, and courts have consistently rejected the legislative privilege in those cases. If the Fair Districts Amendment sponsors wanted to abrogate the legislative privilege, they certainly could have put a provision into the amendment to do that. They didn't do that. And so just as it doesn't abrogate other privileges that might apply, it doesn't abrogate the legislative privilege, and that's something that we think the voters should have known about expressly if that was the intent of the amendment, which we don't believe that it was. And in the broader context, Your Honor, this is the balancing test is not simply in redistricting cases. It is a general rule, broadly applicable to every case, and no matter the context. And that is why the balancing test is so injurious to the legislative process.
So is it your argument that, for example, there might be a slander charge against a legislator, and under apportionment 4, there could be depositions taken of the legislator and the staff? Is that the kind, I'm looking for examples of why this is so critical outside of redistricting, since you just said that.
I think what we see in the legislative privilege cases that come up is routinely in civil rights cases, whether it's Fair Districts amendments or whether it's amendments to the election code. In Florida versus the United States, it was Section 5 of the Voting Rights Act.
So if there's a remand in the Black Voters Matter case that's pending before the Florida Supreme Court and further factual finding, there were several questions regarding how that case was resolved on stipulations. There wasn't a trial. If there is a trial and there is a remand, it's your argument that legislators and their staff cannot be deposed?
Well,
that we should say that, for example.
Yeah, well, first of all, the plaintiffs in this case have stipulated that they will not seek further discovery, and so we take them at their word on that. But
well, in fairness to them, that might have been before a remand was ordered.
Maybe so. But yes, our position is in civil litigation, the legislature needs protection from that. And obviously criminal has been treated differently in the Gillett case and others. But in civil litigation, the legislators need to know that when they take positions on bills, when they serve on committees, when they cast their votes and they decide what part to take in the legislative process, that's not going to embroil them in civil litigation.
And private conversations with staff.
Including conversations with staff, yes, Your Honor. And I see that my time is almost up.
And I'm going to give you yet another 3 minutes, so that means, Madam Clerk, 8 minutes, if my math is correct, for the appellees.
Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Jyoti Jasrasaria on behalf of appellees, and I'm joined by Fritz Wermuth. This Court just heard a whole host of reasons that appellees do not like the rule that was set forth.
Let me ask you that question. Do you think they were required to file a petition for a writ of certiorari? Or do you concede that they had, this Court has jurisdiction on direct appeal? I know that hasn't been discussed in the briefs, but of course a court has to guard against exercising jurisdiction when it has not.
Absolutely, and appellees here do not argue that there needed to be a writ of certiorari. I think what we do argue is that this Court does not have jurisdiction for several other reasons, most notably
I mean, if we did find that it was required to be raised by writ of certiorari, I think it might be difficult to show irreparable harm where a subpoena notice has been canceled, right?
Correct.
You wouldn't concede that there was irreparable harm, right?
Absolutely not, correct. So I will certainly address appellant's arguments, but first I wanted to make clear 3 key points that are not in dispute here. So first, appellants concede that the underlying dispute is moot because plaintiffs have withdrawn their deposition subpoenas to legislators, and they've also withdrawn all of the legislative intent claims. Second, appellants concede that the trial court properly applied Florida Supreme Court precedent, and while they may not agree with that precedent, certainly this court and the trial court are bound by it. And third, all of the cases and courts that appellants cite from Florida and across the country recognize that the legislative privilege is qualified, and many of them apply a balancing test similar to the one that was applied in Apportionment 4 and which the trial court applied here. So it is appellant's
Do you
position.
have an outstanding cost claim? So say we agree with you and dismiss this appeal. Will you go back and seek costs from the trial judge for the litigation in this case? Or are
We
you
don't
willing
have,
to concede it today? I don't see it addressed in the stipulation, but Judge Thomas and I were on the same panel in a Kendall healthcare case where an outstanding fee and cost issue defeated mootness. So I need some clarification from you on what's your position on your outstanding cost request?
sure, so the outstanding cost, any outstanding cost request is not as to the non-party legislator. So I would agree with the appellants on that matter, that would not affect mootness inquiry here because there's no cost request in the stipulation or elsewhere about this particular matter.
But you're not withdrawing all cost requests altogether? You're qualifying it?
Sure, I'm not in a position today to withdraw all of the cost requests from the litigation generally, but for the, those cost requests are not against these specific legislators that are bringing this appeal.
Can you concede that, based on our decision today, it would or would not affect the outstanding cost request? Any effect whatsoever, no matter how we rule today, on your outstanding cost request?
I would agree that I don't see how any decision on this appeal would affect the cost request as to the merits of the case with respect to the diminishment violation. So again, I'll just say that appellant's position in this case is the one that's the outlier, not the Florida judiciary's. And this court's path is clear that it should dismiss the case.
Yes, I noticed the motion to dismiss has not been ruled on. So you want us to grant the motion to dismiss?
Correct. And I'll start there. This is, before we even get into the exceptions to the mootness doctrine, appellant's arguments fail as a matter of first principles. And that's because they're purporting to bring this appeal in the name of separation of powers, but they're asking this court to overstep its own constitutional role and thwart the case or controversy requirement that this court has recognized is rooted in judicial fidelity to the very separation of powers doctrine. And again, none of the exceptions apply here. So I'll start with public importance. In Apportionment 4, the issue of legislative privilege was important because the Supreme Court had never decided whether such privilege existed. But now that that issue has been decided, that reason no longer exists. And as the Florida Supreme Court stated in Apportionment 4, what is of paramount public concern in redistricting is how and why the legislator redistricts. And so
Repeat that again, I'm sorry.
Sure. In Apportionment 4, the court said that how and why the legislature redistricts is a matter of paramount public concern. And obviously that's not an issue in this case, but to the extent there's anything that's of public concern here, it actually cuts against the position that
I'm sorry, I'm not sure I follow that logic. You said the court in Apportionment 4 said these issues are of paramount importance, correct?
They said that the issue
Redistricting.
of how the legislature redistricts.
Right.
So the actual, what might be uncovered in discovery is something that's important, not necessarily that the issue of legislative privilege is important. And to the extent that was important in that case, it was because it had not been decided. So here, all that appellants are
Well, if that's
relying
of
on.
paramount public importance, how is the legislative privilege not of great public importance? Again, I'm not following that logic.
Sure, so.
If the issue of, for example, in Black Voters Matters, as we all know, intent, animus was not an issue. But if it were in a future redistricting case, isn't it important to know whether or not, in fact, under Apportionment 4, you could, if you were representing the plaintiffs, you could take the legislator's deposition, right?
Well, all that apportionment 4 did was establish a balancing test, and
Right.
and that balancing test allows for, in certain cases, it's a very fact-specific
But obviously,
inquiry.
I mean, the tenor of your brief, the statements you've made in your brief, both in this case and in Black Voters Matters, there's no question you would be, in fact, you tried to take the legislator's deposition in this case. You withdrew it, but obviously if there's a future redistricting case, you're likely to require legislative depositions, are you not?
I don't think that we would concede that, because this case actually shows that legislative discovery is not always at issue in a redistricting case, right? In this case, the issues that remain are effects-based claims, and for which there was no legislative discovery required. And certainly, it's not for appellees to assume that a future legislature would violate the Fair Districts Amendments in a way that would require such legislative discovery. And
I mean, in Black Voters Matters, the parties apparently essentially stipulated their way to a final judgment. But if there's a remand, if there's a trial, if there's a question of legislative animus, are you suggesting that your plaintiffs or another set of plaintiffs in a similar case would not subpoena legislators and their staff to ask the questions such as, did you not look at the race of the constituents and the political party to make sure you protected one party over another on the basis of race? Isn't that the first question that would be asked?
well, in this
a
case,
deposition, under oath.
sure, but in this case, there are no intent
I
claims.
know there's not in this case, you've withdrawn the notice. I'm asking you because it goes to whether or not it's likely to recur in the future. Maybe even in this case on remand, if there's a trial, which Council in Black Voters Matters requested a remand, should the court look to prior discriminatory practices. Now, perhaps there wouldn't be a deposition on that specific point, but couldn't there be a situation where the plaintiffs in a race discrimination case or a Fair District Amendment case would demand that legislators and their staff submit themselves to sworn depositions?
Well, I certainly don't want to speculate as to what discovery may be needed in the Black Voters Matter case or any other case. And I think that just goes to the fact that this is a very fact-specific inquiry, and any
So you don't think depositions would ever be required in a future redistricting case?
I think
Is that the principle we should kind of follow?
No, I absolutely think that there could be a need for depositions in a future redistricting case, although I certainly wouldn't want to presume that we would be in that situation if the legislature follows the law.
I'm not asking you personally, but lawyers in a fair district case arguing discriminatory intent or racial animus are certainly going to want legislative discovery, aren't they?
I think if there's
They're not going
certainly-
to leave that on the table unanswered.
No, absolutely. And I think that, what appellants cannot do here is credibly argue that if these issues were to likely recur, that they would not be evading appellate review, right? Because that's something that we have seen in apportionment for itself.
But they argue that evading review is not a criterion that binds our analysis.
Well, they may
That
not.
only applies to the trial court.
Sure. I mean, they may not like that standard, but
You disagree?
I disagree, and it's true that courts sometimes refer to the standard as just the likeliness to recur, but appellants have not pointed to any case stating that the evasion of appellate review is irrelevant, and the only case that they cite doesn't say that. In fact, it's a Florida Supreme Court case that decided an otherwise moot appeal because the district court below had misread Florida Supreme Court precedent. And that's the Dorsey v. State case. But here, there's no disagreement about the state of the law, and everyone agrees that apportionment 4 governs this case. And so the likeliness to recur, even the appellants say that the reason for that exception is to make sure that courts have guidance, and that, a lower court's incorrect resolution of the question won't cause future problems. But here, there is no such need because the Supreme Court's already set forth that guidance. And just because appellants don't like that guidance doesn't mean that the courts all of a sudden will need new guidance. So certainly here, the mootness exception doesn't apply, and if this issue were to present itself, as Your Honor is suggesting, it could be decided then. And I think that just speaks to the underpinning of all the mootness exceptions, right? It's this idea that the court needs to resolve some kind of uncertainty or provide guidance, and again, that's not what the court would be doing here. It would simply be affirming the decision below, as appellants concede, based on the state of the precedent here. And that brings me to the point about whether appellants are actually asking this court to write an opinion. They have not asked for that. They've simply asked this court to certify the question directly to
Which leads to my questions of your learned opponents, right? Which is, do you think the Florida Supreme Court is interested in our view? Should we agree with the appellants that they decided apportionment 4 wrongly?
Well, I certainly think that it's telling that the same legislature that's asking this court to now write an opinion disclaimed any support for the opinion last week. And so,
Well, the legislature in Black Voters Matter didn't argue the jingles criteria. So they were foreclosed, as it were, from that argument. So it's somewhat, shall I say, incorrect to suggest that, well, they weren't interested in your opinion last week in Black Voters Matters because they weren't relying on that argument. But it is accurate, if I'm not misreading last week's argument, that our opinion, our en banc majority opinion, after an en banc oral argument, was essentially not discussed in the entire argument. So I'm asking you, as a practical matter, do you think the Supreme Court is interested in our opinion? Should we agree with appellants in a written opinion suggesting that they decided apportionment 4 wrongly?
you know, I certainly don't want to speculate about what the Supreme Court will.
Well, I'm basically asking you, what impact do you think there would be if we wrote an opinion and said, by the way, we're certifying a question because apportionment 4 is, as appellant stated, egregiously wrong from the outset, and therefore we wouldn't urge, we recommend, I guess, that you reconsider apportionment 4, or we ask that you look at. I mean, what is the impact of such an opinion, in your opinion?
I can't speak to that, but what I can say is that the appellants have waived any argument that this court should even write such an opinion. All they're asking for this court to do.
And that's an interesting point, and that's why I asked opposing counsel, are they essentially asking for a PCA with a certified question?
Certainly, all they've cited in their initial brief is a desire for some kind of pass-through certification, but they, of course, have, you know, since conceded that that's not what they were doing and that that would be procedurally improper. But there's really just no way for them to ask for the relief they're asking for at this stage of the litigation, given that they withdrew their earlier pass-through certification, and no one thinks that there's a need for immediate
it actually sort of
resolution.
logically ties into mootness, doesn't it? In other words, the appellants are requesting that this court address a matter that you withdrew the subpoenas, and the decision in apportionment 4 is not at issue in Black Voters Matter, but yet we're requested to address it so that there might be Supreme Court review. That seems fairly attenuated. I assume you agree with that.
Yes, no, I certainly agree with that. And I'll just say that, you know, in addition to the mootness, it is also just, I've certainly never seen this court accept pass-through certification, you know, years after the appeal was first filed.
In a closed case.
Right.
But let's talk about the merits.
Sure.
Assuming we disagree with you on mootness and we decide to write an opinion suggesting to the Florida Supreme Court they reconsider apportionment 4. Is it your view that the provisions of the Fair District Amendment trump the strict separation of powers?
So what I'll say is that.
Because the Fair District Amendment doesn't address the separation of powers. The voters, there's no text saying, by the way, this trumps the separate Article 2, Section 3, therefore, as your opponent notes, the legislators and their staff can be hailed into court and answer questions under oath.
Well,
So we can prove our case under the Fair Districts Amendment.
so the separation of powers doctrine is absolutely what underpins the legislative privilege, and no one is arguing that there's no legislative privilege here, simply that Apportionment 4 got it right because it recognized that it's a qualified privilege that can yield when there are important, compelling, competing interests at stake. And certainly the express constitutional provision in the Fair Districts Amendments is just that. And to the extent that the appellants are concerned about the purposes of the legislative privilege, those are baked into the balancing test. The balancing test asks whether the purposes are outweighed by some other interest. And here, Florida voters passed the Fair Districts Amendments because they didn't think that the legislature was discharging the public trust or doing its duty without regard to personal considerations. And so here, the competing interest furthers the very purpose that the legislative privilege is meant to protect. And no one is arguing.
Please. I'm sorry, repeat that last statement, please.
Sure. So the purpose of the Fair Districts Amendments is to make sure that the legislature is able to do its job and discharge the public trust in a way that comports with the will of the voters. And so for the appellants to argue that the opposite is true is just simply incorrect in this particular circumstance.
So in other words, the Fair District Amendment eviscerates the legislative privilege when it comes to redistricting cases.
It does not eviscerate the privilege, and I think that the trial court's
I
decision.
assume from your argument under the balancing test, the trial court is always going to allow the depositions.
Well, I think that what happened in this very case.
I mean, you said the voters, in your opinion, the voters, by passing the amendment, found that the legislature had abused its public trust. So certainly you're going to take their depositions when the redistricting is at issue, right?
Well, I think that, again, it's a balancing test, and it's very fact-specific, and so I think.
I know, but in a redistricting case where racial animus is asserted, I assume in a hypothetical case, it would always be a situation where the allegation, the accusation is that legislators and their staff got together and they said, this racial group votes one way, this racial group votes another way, so we need to draw these districts to protect the party from that racial group. You're going to, not you personally, perhaps, but the plaintiffs are going to want to take and be entitled, under your view, to take the depositions of those legislators, right?
Well, again, I think that the balancing can result in a lot of different outcomes, including the one that was reached here, where the trial court.
Of course, you're going to have to make the decision depending on each case, but, I find unworkable practically this balancing test because, I dare say circuit judges are going to be on standby to, answer the phone and make rulings on objections at depositions, whether something's objective and subjective. It's going to be 3-year deposition, before it all gets flushed through. But that's being set aside. Whether we agree or disagree with Apportionment 4, let's focus back down on what we're here for today, which is, mootness. Do we go forward or not? So if you could continue with your arguments addressing the 3 exceptions.
Sure. So, I've discussed the public importance. I don't think that appellants' disagreement with Apportionment 4 creates an issue of public importance. And in fact, if their view was correct, it would mean that every issue of public importance decided by the Florida Supreme Court could be relitigated by the lower courts even without a live dispute. So that simply just can't be the law. And on the likeliness to recur, I think I'll reiterate that it's not for any of us here to presume what a future legislature might do and what future plaintiffs in litigation might seek. But in any event, all of the cases that appellants and appellees cite just show that these issues are litigated to completion, including review by appellate courts and the Florida Supreme Court before any legislator is subject to a discovery request or a deposition. And so there's no risk that Florida legislators will be hauled into court without the opportunity for a full review on the facts that are at issue. And then turning to the third exception, which is the collateral legal consequences, Appellants throw out that term without really engaging with what such consequences are, and this exception really doesn't apply here, where it's typically used for concrete and particularized consequences to a party's property or rights. For example, when a conviction or an incompetence determination could be used to prevent a defendant from overturning or exercising some right. So I think that it's just not the kind of consequence that's at issue here. But of course, even taking appellant's broad view of what collateral legal consequences might be, any such consequences are not a result of the trial court's decision, which is what would be required for the mootness exception to apply. They are, in fact, a result of apportionment for, or frankly, of the Florida Constitution itself, since, as the Supreme Court said in apportionment for, the chilling effect was the precise purpose of the constitutional amendment outlawing partisan political gerrymandering and improper discriminatory intent. And so it's not the trial court's decision that is potentially changing the way that legislators are doing business. It's actually just the existence of these fair districts amendments and the existence of apportionment for itself. And if, of course, what appellants are asking for is carte blanche to ignore those amendments, then certainly this court should not be assisting in that effort against, the will of the voters who enshrined those constitutional amendments.
So you seem to be saying that if discriminatory intent is asserted, well, then you will need to take the depositions of the legislators, because otherwise the appellants, the legislative branch, can thumb their nose at the Fair District Amendment. That's the logic of what you just said.
Well, what I'm saying is that, again, it's a very fact-specific inquiry, and so we don't have any discriminatory intent claims at issue in this litigation, and there's, the next time this could occur might be in the next decade, and certainly there's no reason to assume that Florida legislators will thwart their obligations.
If you prevail in the Florida Supreme Court, or perhaps the United States Supreme Court, regarding CD 2, I believe, is the recent numerical designation, or 5, then isn't that district line going to be redrawn?
Certainly.
That's what you're asking for, right?
Yeah, absolutely. We are asking for it to be redrawn,
Right.
And but
So
again,
if it's redrawn and the legislature goes back in session, perhaps even in a special session, depending on the ruling, the timing of the ruling from the Florida Supreme Court, let's say, hypothetically, you prevail, and the line is redrawn, and a new claim is raised of discriminatory intent. Is it your argument that, well, it would never be possible that we would try and take a legislator's deposition in that case?
I certainly, again, don't want to speculate as to what we may need, but I think that the fact that
You would
just used,
certainly want that option, right? Under apportionment 4.
I think
You
that.
can certainly see that occurring, right?
So I think it's possible that that would happen, but I think, as Your Honor said, there's so many hypotheticals.
That's not that many hypotheticals. You want the district redrawn.
We want the district redrawn, but
You're arguing that the district is invalid. You want another district redrawn, correct?
we absolutely want another district redrawn, and
if the legislators redraw that district contrary to your interpretation of fair district amendments, you are willing to take their deposition, correct? And the staff.
so again, I don't want to speculate as to what the legislature might do, and certainly
But you
don't
want
want
that
to.
option.
Well, I don't want to presume that the legislature would violate the fair district
Well, you
amendments.
just argued in Black Voters Matter that they did.
And we argued that they did on an effects-based claim,
Right.
and we would hope that the legislature, if it were, asked to redraw, would do so in a way that comported with the amendments. And for us to assume that, they would not, I think is again, just shows that this is not likely to recur, right? The standard
I'm
is
just
likely.
asking a hypothetical. Assuming they redraw the line in a matter unsatisfactory to your clients, would you not assert the right under apportionment 4 to take depositions? It's pretty much a yes or no answer.
And I think the answer would be yes, and that any legislative privilege
Then it's likely to
concerns.
recur.
Sorry?
Then it's likely to recur.
Well, I don't know that I would say it's likely, but because, again, there are many inferences.
It's possible to recur.
It's possible that it would recur, and if it were to recur, there would absolutely be an opportunity for the courts to look at the facts of whatever deposition or discovery requests were issued to make that determination at that time and do the really careful balancing that the trial court, did here and that the apportionment for decision would dictate. So there's no reason to prejudge what might happen in the future when there would be an opportunity for such litigation and appellate review at the time that such, discovery may or may not be issued.
Madam Clerk, please give the appellees 2 more minutes and add 2 more minutes to the appellants, please. I don't want to cut short any landing you might want to
Thank
do here.
you. So the other thing I'll just point out is that apportionment 4 is entirely in line with the weight of precedent in Florida and federal courts that apply a balancing test to determinations of legislative privilege. And that includes Expedia, which is, of course, the first DCA's case that appellants cite favorably as applying the correct standard. That case, too, recognized a qualified privilege and, in fact, applied the exact same test that apportionment 4 ended up adopting. And just because appellants don't like the outcome of one of those cases, whereas they do like the outcome of the other, doesn't mean that the balancing test itself is wrong. And in fact, the outcome-oriented like and dislike that appellants seem to have simply proves that this is a very fact-specific test and that the court's inquiry in this case is inappropriate, as there really aren't any facts to adjudicate. And so I'll just close by saying that this appeal is a blatant attempt to circumvent the will of Florida's voters who enshrined into the Florida Constitution amendments to hold the legislature to account in the redistricting process. Precisely.
And how is this appeal a blatant attempt to circumvent the will of the voters?
Because in this appeal, the legislators are seeking to use an abstract, hypothetical appeal to further inoculate themselves from being held to account by those very same voters who they are elected to represent. And they are essentially trying to get a free pass not to abide by those amendments, because without any possibility of discovery, again, we would hope that no one would need it here, but to give them a free pass now would simply render those amendments ineffective in many ways. And so this court—
Can I translate free pass into, essentially, let's shortcut it into an opportunity to readdress apportionment 4, period? That's what they're asking us to do. In your brief, you're arguing this is nothing more than an unsupported, from a procedural standpoint, attempt to readdress apportionment 4, period.
Correct. Right, this is unsupported, and because there are no facts at issue, there's just nothing for this court to decide, and appellants would concede that. And so this court should not let the legislature use it as a pawn in the effort to undermine the Fair Districts amendments in this hypothetical appeal. Thank you.
Thank you.
Thank you, Your Honor. I'll begin with a couple of procedural issues. This issue of appeal versus certiorari, we filed a response to the court's show cause order in December of 22 that lays out our position on that. So I'd recommend that to the court. On the issue of pass-through jurisdiction, we're not seeking pass-through at this stage. We did seek pass-through earlier, but when they withdrew the subpoenas, that mitigated the urgency of a decision, and so at that time we withdrew the pass-through request. At this point, we are seeking a decision from this court, which is why we appealed, and then the certification of a question of great public importance. So I think it goes without saying that we're here seeking an opinion from this court on appeal, plus the certification of a question recognizing that apportionment 4 is binding. As to Your Honor's question as to why the Florida Supreme Court would give way to this court's opinion, I think one thing that this court's opinion could do that the Florida Supreme Court would find very instructive is demonstrate the development of the law since apportionment 4 was decided. We have had a significant number of legislative privilege decisions, primarily from federal appellate courts during that period of time, that show the progression of the law in favor of an absolute privilege in civil cases. And we think that the development of the law in that direction makes apportionment 4 all the more an outlier. It was wrong when it was decided, and this court's opinion could demonstrate that it now is an extreme outlier when it comes to the legislative privilege. You heard from counsel they're unwilling to disclaim an intent to take further legislative discovery. It sounds like even in this case, despite their stipulation, that they wouldn't do so. That by itself, I think, Your Honor, is very telling. But I think we have to also back up and recognize that this issue that we're presenting to the court is not about necessarily one case or even about redistricting. It is about the impact that apportionment 4 is having on the legislative process and its applicability to all cases. The Florida Supreme Court in apportionment 4 articulated a generally applicable rule, this balancing test, and it is not limited to redistricting. It applies across the board. And it's a balancing test that requires trial judges to balance the interest in discovery against the purpose of the legislative privilege, which, as Justice Kennedy in his dissent in apportionment 4 recognized, confers unfettered, in his terms, unfettered judicial discretion on trial judges. And that is what impacts the legislative process and why it's important that this issue be addressed now, because the legislature legislates in this environment. It legislates with this decision impending over it like a sword of Damocles. It is operating under this precedent, and that informs the decisions that legislators are making in the legislative process. So whether or not that decision is used intentionally to affect or sway their conduct in the legislative process, it can have that effect because the fear of being dragged into litigation simply because of the part they take in the legislative process is significant, and the legislative process should be protected from that, as federal courts have consistently recognized, certainly since In re Hubbard was decided. And that really goes to the public importance issue. And the public importance issue is one that I think the appellees have failed to adequately address. One thing that we have not heard from the appellees is whether apportionment 4 in fact adequately protects the legislative process. They do not assert that it does. That is not an argument that I hear them making. We hear an attempt to portray this as a garden variety discovery dispute or to present procedural arguments, but they do not defend apportionment 4 on the ground.
What I heard them say is unless they have the right to take legislative and staff depositions, it means that the legislature can, how did they put it?
Free pass.
Basically ignore the Fair District Amendment.
Right, Your Honor.
That's a fairly serious description, I think.
Yes, Your Honor. And we, of course, disagree with that for all of the reasons that other courts that have rejected this argument have recognized. Parties, time and time again, have argued that when motive or intent or purpose is at issue, we need the opportunity to take legislator depositions in
Well, I
courts.
mean, logically, if it's at issue, they will take the depositions. And they will require sworn testimony.
And they will, and that is
And
why.
if they assert to a state attorney that a legislator or a staff person has not told the truth, they will, I'm not saying they will, that person is subject to the second-degree felony of perjury.
That's right, Your Honor.
Punishable by 15 years in state prison.
That's right, Your Honor. And that is why the legislators must have the ability to act and to vote and to speak freely within the legislative process without that apprehension. And we haven't.
But you truly think, despite the fact that the subpoenas notices were canceled, that there's certainly a question of jurisdiction, we'll certainly take another look at your response, that if we write what they describe as an academic exercise with some logic, that, oh, by the way, Supreme Court, even though there are no depositions in this case, we just wanted to let you know that we think apportionment 4 was wrongly decided.
Yes, Your Honor.
You think that is of value?
I'm sorry, do I?
You think that is of value
Yeah, I
to
do
the
think.
Supreme Court?
I absolutely do think it's of value. I don't think it's an academic exercise. I think the Florida Supreme Court would recognize that this decision is having an impact currently on the legislative process. And if the opinion that this court issues, as it would, demonstrates to the Florida Supreme Court that this is an issue on which its precedent has become more and more isolated, more and more of an outlier, and that it poses a present risk to the legislative process because of the consequences of potential legislative discovery, I think that is precisely what the mootness exceptions exist to address, an issue that requires resolution, notwithstanding the mootness of a particular appeal, because of the implications of the decision. And I would urge the court to do that. I think Justice Kennedy was right in his dissent when he said that apportionment for grievously misconstrues Florida Constitution. We would urge the court to issue an opinion and certify a question of great public importance.
Thank you both for your arguments. The court's in recess.
All rise.